give us the okay. Thank you for coming back. Now we'd like to hear from the respondent. The applicant took almost 70 minutes. In all fairness, I will give you the same time. I understand we do have a room beyond 10 o'clock, so you've got 70 minutes to cover your or less, whichever. Go ahead, Mr.
Thank you. I am going to ask for your indulgence to some extent. In an ideal situation, I would be able to have all my thoughts on each topic gathered together. The reality of the situation that I find myself in right now with a 5-minute break is that I have notes from the earlier 30-minute break. I have notes that I scribbled during the hearing, and I have some notes that actually do turn out to be pertinent of what we guessed might be the substance of the complaint. I'm not certain that I'm going to be able to group them adequately, and I'll apologize for jumping around and appreciate your indulgence with that, but I don't know that I have an option without a half hour more to prepare.
Do you need more time?
No, I don't think I want to do that.
Well, I'll appreciate
I would rather have your patience and your alertness rather than going well past 10 p.m.
No, that's fine. I just found out that we have the room beyond 10 o'clock. In fairness, I'll give you the same time which I allowed to the applicants to present their prima facie evidence and submissions they have, and walk us through the binder and all the exhibits.
Yeah.
I'll give you the same opportunity. You have given us the booklet here. You have your notes. You have your client next to you. Okay, feel free to consult. But I'll appreciate all the points which were raised in 6 issues and allegation of various alleged violation of the Municipal Election Act. If you can be specific to those allegations in your response, rather than going on technicalities and legal jargon and court references, because we are citizen-appointed committee. We are not playing a role of an auditor. We are not here to play the role of our lawyers here. We're hearing from the city perspective to ensure that the law of natural justice has been applied. Both parties has been given fair chance, equitably. We heard both submissions and response, and then we'll make a decision if the application to accept or reject and appoint the auditor. So, 9:30.
Thank you, Mr. Chairman. I hear you loud and clear on the law. So I do have some submissions on law that I'm going to shorten dramatically in light of what you say, and I think that it's appropriate.
And I hope you understand from our perspective.
I really think I do. I don't think I can get around to discussing with you what the test is for holding a compliance audit. What justifies a committee such as yourselves to hold or to order a compliance audit? What the Act says is that an elector who's entitled to vote in an election believes on reasonable grounds that the candidate has contravened the provision of the Act may apply. That's Section 81 sub 1. Section 81(5) says that the committee shall consider the application and decide. The committee has a discretion over and above whether or not it even identifies reasonable grounds, because reasonable grounds does not appear in the provision talking about your power. But in order for there to be anything properly before you, there must be a belief on reasonable grounds that a candidate has contravened the Act. So I'll jump forward, and I'm on paragraph 15 of my written submission if you want to follow along. Page 3, tab A. There's a really, in my submission,
Sorry, what do you want to?
tab A,
Tab A.
my current submission, page 3, near the bottom, paragraph 15.
You're referring us to the court case?
I'm referring you to the court case, because it sets out...
Sorry, did you say tab A?
Tab
A.
1.
No, A.
We have 1, 2.
No, the 1 is A.
Tab A,
That's,
tab A,
Yeah.
page 3. The belief of on a reasonable ground threshold.
okay. Under that heading, near the bottom of the page. This is a court decision arising out of the 2006 Toronto election compliance audit appeal. And what the court said here, it also strikes me that even if the appellant had what he considered reasonable grounds to ask for an audit, the appellant being the person in Mr. Cashin's shoes for purposes of terminology, the committee has considerably more information at their disposal. Having heard all the submissions and reviewed all the material before them, the committee is in a better position than the appellant to determine whether in fact reasonable grounds do exist. The point here is your assessment, not Mr. Cashin telling you repeatedly, I believe, I wonder, I think. Your assessment that needs to be
I understand that fully.
And then, the key sentence here, it is the role of the committee to weigh the evidence and make determinations of what weight should be according to the representations before it. In a separate place in that case, what Justice Lane, the judge in Lyra, said was that what is required in assessing reasonable grounds is an objective belief based on compelling and credible information which raises a reasonable probability of a breach of the statute. All four of these things must exist for the complaint to have any legs at all before you even think about applying your discretion. An objective belief, not I personally think, but genuinely believe. Second, that it is based upon compelling information, not speculation, not I wonder, not maybe a compliance audit will reveal. It has to be credible information, something I would submit more than we phoned some polling company and they told us this. There's some documentation about a quote from a polling company, that's fine. That might be compelling, except it doesn't show anything about what was actually paid on an issue, as I'll come to, where the only question is whether or not it would constitute an expense that could not have been incurred prior, and a reasonable probability of a breach. So keeping this in mind, and your role in my submission is as a custodian of public funds. You determine whether or not the city of Mississauga is to spend whatever it takes to conduct a compliance audit. And why this is important today, more so than in previous election cycles, is because an individual has the right, since the 2009 amendments to this legislation, to go before a justice of the peace and commence a private prosecution. If Mr. Cashin should choose to do so and persuade a justice of the peace of reasonable grounds, and then be unsuccessful in his prosecution, he's liable and at risk of a lawsuit for malicious prosecution. You, in ordering the audit, would insulate him from any such risk at no small expense to the city. Your discretion is then required in order to determine whether or not the expense is warranted under all the circumstances. Really, that's all I need to say. I'm going to come back probably repeatedly.
So I hear you
to the
understand,
phrase
committee
about
knows its
compelling.
role.
No, but I'm going to come back because it's so clear in what Mr. Cashin had to say that there is no objective belief. There is subjective wonder about whether or not this is so. There is no compelling information that would support a finding of a breach. There's no credible information that would support a finding of a breach. And then at the end of the day, you apply your discretion to whatever you might find left. I submit there is none. So let's move on to the issues. The poll. Mr. Cashin says that $236 for a poll is unrealistic. That's not the issue. Mr. Cashin says that maybe this poll, as described by Mr. Siegel last time, isn't the full extent of what was done. That's not the issue. The issue The only issue, the only possible breach arising from the polling was a campaign expense incurred before the candidate had registered. I'm sorry to have to rummage through papers now. I'm going to get to the right place. I'm just looking for my copy of the act. Here we go.
You refer to the section, copy of the...
I will. Just the section of the... I assume you've been provided with the legislation.
Yes.
Okay.
What section are you on?
The definition of an expense is section 67.
671?
67 sub 1. The purpose, because nothing in the following section or subsections relates to the issue of polling. It's the general definition in sub 1. For the purposes of this act, costs incurred for goods or services by or on behalf of a person, keywords, wholly or partly for use in his or her election campaign or expenses, for use. In order for whatever it was that was conducted, whether it was, as we provided information previously, a $236 fairly lame poll, or whether it was some kind of elaborate polling that the Riding Association reported in the material that Mr. Cashin refers to, whether you use Angus Reid or Solus, whatever. It doesn't matter. The question is whether or not there is credible or compelling information before you to show that information garnered in such a poll was used in the campaign. The only information we have, that you have, it's one and the same, that Mrs. Crombie has, is the information as to whatever number, I forget the number of callers, respondents said, how they ranked these 6 prospective candidates, or 5 declared at the time candidates and 1 prospective candidate. That informs a decision about have you got a hope. It can't possibly provide the kind of elaborate strategic information that the polling companies refer to in the Ipsos book, that Mr. Cashin refers to in his submissions about tailoring a message, about a scientific breakdown of populations. It's nothing of the sort. It's a snapshot of a horse race. And it's a snapshot of a horse race that hasn't even started yet. Maybe even a better analogy would be talking to the bookmakers before the race begins and getting their assessments. It's no more than that. It absolutely could inform a decision whether or not to run. My client tells me that it wasn't even all that helpful to that. It was too rudimentary and superficial a poll. She made the decision to run. There's no evidence that she made use, once she had made that decision, of the poll, and this cannot sustain any sort of finding whatsoever that the poll was an expense incurred for use in the campaign. The costs are irrelevant. The question of whether or not the information we have is the full extent, I assure you that it is, but it doesn't matter. Whether there's any kind of in-kind reporting that goes behind the scene, or whether the Federal Riding Association paid the full poll cost, none of this is relevant. Mr. Cashin in his submissions, and do I have it here, at paragraphs 35 to 36 to 38, I might have a moment, makes assertions of what the law is that have no basis in law. He says that conducting a poll in advance of registering as a candidate in a municipal election, no matter what the cost, is a clear breach of the Act. It is not. In order to make it a breach, he has to get through the initial threshold of it constituting an expense under the definition that I explained to you. That expense is for use in the campaign. The true market value is completely irrelevant to any of this, unless he can show, and he has not done so, that it was for use in the campaign. That it was in fact used in the campaign. And then he says in paragraph 37 that further breaches may have occurred. And this is going to be a recurring theme of my submission. What may have occurred, what might have occurred, what he wishes had occurred so we'd have a stronger case. None of this is relevant. What is relevant is compelling and credible information about an offense having, or contravention, to use the correct wording of the Act, having been committed. It is not before you, and there would be no basis for you to make a ruling accordingly. The ruling last time remains correct. I might have a moment. I want to sift through my notes on polling and see if I've left anything out. So I try not to jump around as you asked. There's a passage I objected to during the submission I'll come back to about Mr. Thomas's withdrawal, simply to add that it's most inappropriate. Whatever led to his withdrawal is outside the scope of your jurisdiction with respect to the finance provisions of the Act, and it is total speculation, improper in my submission, and it's certainly not anything that has a basis in compelling information, reasonable belief, or credible evidence.
That's issue number one.
That's my wrap on that issue.
I have a question on that. We'll go issue by issue.
Yeah, that's fair.
I'll give the same question. My question is, did she conduct the poll?
Did she conduct the poll? It was conducted for her.
Yeah, for her. She spent the money, $226?
I understand. $236.
$236?
Yep.
What this poll was used in her campaign for the Ward 5 election.
It was not used. It was used to help make a decision about whether to commence.
Randy, any questions? Mr. John? No. Richard?
No.
No. Issue number two.
Issue number two, signs and stakes. They're kind of blurred here. Mr. Cashin went on at some length about
Two and three we addressed together, so if you want to answer.
I'm going to have to do the
just
same.
2 and 3?
Where's, give me a moment, please. They're blurred throughout. The issues relating to the signs, the stakes, the involvement of federal political entities. I don't know how else to describe it. Need to make a couple of things clear. The signs and the stakes were acquired by Mrs. Crombie's campaign. That is not a federal political association at all. As you will see at the tabs where Mr. Cashin provided from binder, the material at tab 9 is the candidate's electoral campaign return. A candidate under the Canada Elections Act is an individual person. They receive transfers of funds, or allowed to receive transfers of funds, and this candidate did, from a federal party or riding association. But the campaign is distinct. It is personal and it is her. 2008 and 2011, both. The riding association may or may not acquire things. In one case, I believe in one of the cases the signs were purchased from the riding association, which acquired them in advance. But they're purchased by the campaign. Now, it's impossible to stay away from talking about law here and kind of technical law. In order to own something, the owner must be a person. A person in law is either a corporation or an individual person like yourselves and myself and Mr. Cashin. An electoral district association is not a person. A campaign is not a person other than the individual. So when Mrs. Crombie's campaign acquires signs, the owner of the property is Mrs. Crombie. There is simply no legal issue about where did the money come from. The value of these signs is, according to the Act, the lowest price, and I'm paraphrasing the Act a little here to keep pace going, the lowest price that would be charged in fair market for the equivalent material. So what's your acquisition cost? You can look at it two ways. You can look at it as the signs were used up, they had federal liberal logos on them, they had her name all over them, they were of no value to anyone. In my submission, the acquisition cost to Mrs. Crombie at that point would be zero. But you can look at it another way, and that's the way that, in fact, her auditor reported it. Even though it may not be necessary, because I actually tend to agree with Mr. Cashin that Schedule 3 of the return is intended for municipal elections. But what you have here is really over-disclosure, not a failure to disclose, and not a lack of transparency.
But she does bring those fair market value of inventory.
That's my point.
Worth of $7,000.
That's my point. That's a valuation that's being put on them. They are her personal assets, and she has the right to do this. But she doesn't have the right to ignore them in calculating her campaign expenses. Mr. Cashin did a fairly good job of setting up a straw man and repeatedly knocking it down when he spoke about how she has these benefits of having her profile built up by having been a federal member of parliament, having been a federal candidate, having had the benefit of obtaining these signs. But there's no law against that. What the Act says is that what an individual acquires, their property that they put into the campaign, their contributions to the campaign, whether it be of cash or hard assets, are without limit. Campaign can put in anything at all. And what's done on that Schedule 3 is to state, for fairness and transparency reasons, the appropriate market value cost, whether you talk about replacement cost or fair market value, is immaterial. A fair value for campaign purposes having been placed on these signs and stakes. Now, the valuation was based on the invoice cost charged most recently in the 2011 campaign to her campaign, her federal campaign, for equivalent material by Lakefront Graphics. They charged $5.99 for 40-inch by 32-inch coroplast signs. Coroplast is the hard plastic stuff that looks like corrugated cardboard only it's plastic. And rather than figure out what it is, we've got small signs, we've got large signs, we're bringing in these signs that are her property and have to assign a value to them. If anything, in order to be conservative here, we're going to estimate them all as being equivalent to big coroplast signs. They brought in something of the order of 1,000 signs in total. In fact, as I understand it, in the most recent inquiries, about 800 of the signs came from the 2008 campaign, and they were what was intended to be used throughout. Federal campaign, 2008. That on the eve of the election, after they'd run out of those, they hacked up to 2011 signs, cut off the words re-elect, or covered over the words re-elect, the Liberal logo that was on them, to replace signs that had been damaged. You saw a picture of how the signs get damaged. They're her property. All that you see on Schedule 3 is a fair evaluation of the cost to be declared, because when using this contribution of goods and services, she is required to declare the expense. So rather than, as Mr. Cashin would have it, take advantage of her federal status, and I would say it would probably be correct for her to leave that Schedule 3 blank. Because as Mr. Cashin says, I think really the intent is that it be for municipal leftover inventory. But there's greater disclosure and greater transparency in what went on and where the signs came from and where the stakes came from if you listed them. Then the second half of that schedule, where it talks about what's left over inventory, that's appropriate. That needed to be there because they're the material that they had in inventory, brought in at zero actual cost, but a declared fair market cost. Phrasing fair market gets inappropriately used, but it really amounts to the same thing. The market cost, it's brought in. So you have to include what your leftover inventory is for the report, because the form requires it. The Act doesn't actually. So what you have here is personal property that has been included properly at fair market value, or market value. Again, I keep slipping to fair market value because that's the federal rule. The Act here is more specific about the lowest cost that would be charged to somebody in the marketplace. They're reported at market value in the return. What they're and they were all costed regardless of the actual size of the sign. Grand total number of signs being 1,000, about 800 from 2008, about 200 from the eve of the election from 2011. And they were all costed for this purpose based on the cost of a large 4-foot by 2.5-foot sign, rather than separating out the bag ones that you saw, the little ones, and engaging in an exercise of complexity and precision that might reduce the declared cost, but might also be prone to error. By declaring a larger value, the auditor has erred to caution in my submission, and there's simply no problem and no risk that any spending limit could possibly have been exceeded. Again, I might have a minute to look through my notes and see if I've covered all the signs. Mr. Cashin, okay, here's one. Mr. Cashin made quite a deal about Mrs. Crombie's status somehow still as a candidate under federal law during the by-election. It's a red herring. It's meaningless. Plainly, the intention of the Act is to prevent a candidate, this does refer to federal and provincial candidates, to prevent the candidate from transferring assets from their campaign to someone else's municipal campaign. Why is that critical? Because they would be tax receipted funds, but they're talking really about funds here. If, in fact, the interpretation that Mr. Cashin would give is that someone who is a candidate may not contribute to a municipal campaign, then it would follow that she could not contribute $750 in this by-election campaign to her campaign, or to Mr. Cashin's campaign, or to Mr. Young's campaign. That somehow her status as a federal candidate denies her the rights under the Municipal Elections Act that any individual has. It makes no sense. The law says, for the courts of as high as the Supreme Court of Canada repeatedly say, that an interpretation of the law that produces an absurd result is not a correct interpretation of that law. And if necessary, you may even have to contort the language. I don't think you need to do so here. But you don't produce absurd results. The law is presumed not to be absurd. It is absurd to think that the province intended to prohibit individuals who were candidates in an election that has already taken place, and who are candidates under the federal legislation strictly for purposes of their reporting obligation, to be limited in some way from what they can contribute to a municipal campaign, whether it be by way of cash, or in this case, by way of her personal property. She was absolutely free to do it, and that is not what the Act intends. The fact of the matter with respect to these signs is that they had no commercial value in the federal world after election. They might if she runs again, but the problem with the 2011 signs is that they have the word re-elect on them, and the name of the riding association, which made them completely nonsensical to use in this context. Re-elect wasn't on the other ones. They were cleaner from 2008, which is why they were predominantly used. But they have no commercial value to the outside world. She acquired them, my interpretation would be at zero cost. I think perhaps preferably for these purposes, the auditor's treatment of it at acquisition cost originally to give them a market value. And the same things apply to the stakes. Mr. Cash, in fact, contradicted himself a bit. He referred to the 1 inch by 2 inch stakes, and then went on about Mr. Delaney using 2 inch by 2 inch stakes, which by definition have to be more expensive. It's simply a matter of what is the fair value to assign, and in this case, it's what the Delaney campaign sold the stakes for at the end of the 2007 election. Okay.
They were acquired in 2008.
2008. Yeah, 2000. They would be from the 2007 provincial election. I'm not getting my years wrong, I don't think. They're leftovers from his 2007 campaign, and that would be the return you've got copied there.
Okay, we hear you.
Okay.
Sorry, but the guy was lady. I couldn't see a thing, so I had to change over. Sorry.
Do you have a copy of the allegation issue number 2 and 3?
Yes.
There were 5 items mentioned here.
Yeah, okay.
I just want to give you a opportunity, just go over there.
Okay, okay, you know what, let's go back. Okay.
1 to 5.
1 to 5. A pre-existing inventory. The materials are, I guess the first thing to say, this is I guess in my written submissions when I come through these. I do go in the written submission line by line through these. Mainly raising issue with the fact that we had no information about what on earth Mr. Cashin was talking about at the time. But let's talk about what these obligations are. Section 69(1)G is a record keeping. I'm referring now to paragraph 33 of my written submission, page 7, tab A.
Paragraph 33, your submission?
My written submission is tab A before tab 1 on page 7.
Yes.
Okay.
69(1)G?
69(1)G, it's a record-keeping obligation. There is no means of producing evidence about whether or not records were kept by looking at a campaign return. 69(1)G is the candidate's obligation to keep records of these things. 70 sub 4, accepting signs and states from a federal or provincial entity, I think made it clear that that's simply not the case. They're her personal property. 69(1)E2, according to this. In fact, there is no 69(1)E2. I'm pretty sure, though, that Mr. Cash was referring to 69(1)F sub 2. Again, a record-keeping obligation. A candidate shall ensure that records are kept of the value of every contribution. Sub 3 may be relevant as well, whether the contribution is in the form of money, goods, or services. That is essentially what's done in reporting the inclusion of these pre-existing inventories on Schedule 3. But again, it's a record-keeping obligation. And then 76.4, failing to include full current market value of the candidate spending limit. Oh, to the contrary. That's exactly what Schedule 3 is about showing. I might just have another moment to make sure I've thoroughly tilled this ground, but I think I have.
Okay.
Unless you have any more questions on issues 2 and 3, I'll move on to issue 4. Okay, on issue 4.
I have a question.
Oh, sorry, I jumped the gun. Please.
In 2008, the acquisition of the true fair market value on the Schedule 3, page 7 of 8 of the financial statement form 4.
What tab again?
No, the financial statement,
My client's financial statement. It says tab 3 of the cash advisory, yes. And what tab, what page are we looking at? The Schedule 3?
Schedule 3, page 7 of 8.
Yep.
The inventory of the campaign goods and material from previous campaign used in the candidate campaigns.
Yes.
The two description items, signs and stakes. They acquired 27th of September 2008 and 25th of September 2008. From lead frame graphics and valve delivery stakes. Value total 7,797. These properties were acquired originally by the federal and provincial candidates in the federal.
By the candidate.
Sorry?
I mean, it's hard, 2008, September, both are dates, yes.
That's what the date on the financial.
Yeah, I'm sorry, I'm thinking out loud. That would be during the federal election.
Federal election
2008. So it would be acquired by the candidate, not by the association. This is wrong.
And once the election was conducted of the federal and provincial, those assets or inventory were, according to you, were zero.
They would have an actual value because they're printed with her name.
They were acquired.
They have no value to the outside world anyway.
And they were acquired by Ms. Crombie as a personal asset, which she contributed towards the campaign.
Correct.
Municipal campaign.
Yes.
And realistically, there was a fair market value was established at $5.99 and 90 cents, 0.90375 for the stakes of
Correct.
Berlin. That's how they come with the number 7,797. So, my question is, did she pay for those two items, the sign and stakes, personally?
To the best of my knowledge, she would not have. She would have acquired them at zero cost. They were effectively garbage. Many campaigns simply throw them out or leave them on the roads for city road crews.
But they could have been reused. I think your client wants to use it.
The campaign, again, is her.
Municipal campaign.
No, federal campaign is her. It has no legal, it has no separate legal existence. Any piece of property, such as a sign, going back to where I opened on this, must have an owner. Okay? It cannot be owned by, quote, the campaign. It cannot be owned by a riding association, although I think we made it clear that they were never the property, notionally or otherwise, of a riding association. They were her personal property. How they were acquired was through the campaign. But there's nothing wrong with that. They were acquired by her, or retained by her, or collected by her after the conclusion of the federal election at which time they were worthless. They had a potential future value only to her, and she brought them in, and she made them her personal property and stored them, which otherwise would have resulted in an expense that a riding association might not choose to incur. They become her property as of the date the municipal campaign commences on August the 4th of 2011. There is no other person in this country or in this world who could possibly assert that they owned these signs. They are her property. She is free to contribute anything she wants to her property and to her campaign, as we will come to in a minute, the URL that she used in the internet. And her obligation, because the candidate has no contribution limit, her obligation is to attach an appropriate declared value to the property that she has brought into the campaign, and that's what she's done on Schedule 3.
How were they acquired from her federal campaign, federal election campaign, either through riding association or herself?
There would be no transaction.
Okay. In the submission from the appellant, we heard also that the federal election, any contribution goes to the federal election. There is a federal political donation receipts have been issued. They already paid tax receipts have been issued. Whereas in the municipal election, there's no tax receipts are issued. There's a limit of $750 contribution in the municipal expense by donate contribution by each contributor. So they had some. So the value of those assets, the sign and the stakes, when she inherited from her federal political, you're saying there's zero worthless.
Yes.
Although they were contributed to the federal election.
They weren't contributed. Money that was used to purchase them was. Money that was used to purchase the stakes by the campaign, by Mrs. Crombie, was in fact from contributions that would be tax received. There's no doubt about that. The issue here, and maybe you got to return yourselves to the purpose of contribution limits under the Municipal Elections Act. They serve the purpose of ensuring that no individual is able to contribute so much to any particular candidate that the candidate is then obligated to them should they become an office holder. $750, to put it in the most gross of terms, buys nobody. It is not about, as Mr. Cameron would have it, creating a level playing field. If it was, then the exception in the Act for a candidate or the candidate's spouse to contribute well beyond $750 could not exist. The whole notion here is, what is the candidate's property as of August the 4th, the day that she filed her nomination? And my submission is the signs and the stakes were on that date her property, and the manner in which she acquired that property is completely irrelevant.
Thank you.
Thank you.
Any supplementary question on issue number 2 and 3? No? You can go on to issue number 2. Four and
Issue 4. Let's start with how it appears in the actual complaint. The alleged violations here under issue 4, section 69, 1A, C, G, and K. Section 69 on this opening wording. Candidate shall ensure that. So it's candidate obligations. Do what? A, open a campaign account in a financial institution. no evidence that she did otherwise. Sub C, that all payments for expenses except for nomination filing fee are made from the campaign accounts. We've heard nothing from Mr. Cashin about payment for these things from other than campaign accounts. Sub G, records are kept of every, it's a record-keeping obligation again under G. It's got nothing to do with the return. And K, financial filings are made in accordance with the sections of the Act. The filings are in front of you. Okay, so moving into greater detail into the substance of what Mr. Cashin has subsequently said, I think I'd like to do here for a moment is turn to, I made a note of this paragraph down here. Okay, he's made assertions both about internet and telephone. Now, the assertion he makes in paragraph 81 is that the telephone number was used somehow in the federal campaign. He has no evidence that he has produced of that. I am informed by my client that this is utterly false. It is a personal phone number that she or her husband had on a phone that they weren't using very much prior to the campaign. And they started using it. He asks the question, why is the phone expense so low? Because that was the cell phone bill for the month or so of the campaign that she was involved in. Why did the others have such a large expense? I suspect, without having access to their returns, that they have reported under phone and internet outbound calling. The placing of calls using services, you've seen the names of Prime Contact and First Contact here. Those expenses are reported because they are part of publicizing the campaign. They're reported on the return under advertising. It wasn't the campaign's telephone, and the service is much broader than use of a telephone, and they're reported as advertising. There are, in fact, 2 invoices that are available to you for inspection.
Are they part of your binder?
No. Again, I couldn't anticipate what we were going to hear. It's being raised. But with respect to that, we have 2 invoices from a company called Prime Contact. One for $4,520, another for $39.96. And they are included elsewhere in the return other than under phone and internet. Moreover, I'm informed that the other campaigns had physical campaign offices. Whether they were storefronts, offices, buildings, I don't know. Mrs. Crombie ran her campaign from her home. There were no phone lines to be installed, no internet connections to be installed. Simply using what was there. So there's none of that. The outbound calling is reported elsewhere.
Where was it reported? On what item? The financial
It's reported as advertising, she's telling me.
advertising? Under 20,922?
Out of the 20,922, a total of 8,516 was paid to Prime Contact for the outbound calling to supporters. Those services are for more than simply calling, and you have to make a judgment call. This is advertising yourself. This is promoting yourself, and they're reported there.
But on the same financial statement, if you look up on the page 2 of 8,
Yep.
there's a specific item under expenses subject to spending limit.
Yeah.
Phone and internet is there.
159.59. That's a cell phone bill.
Yeah, but you're saying that she incurred some 2 expenses, the 2 invoices you mentioned.
And they're not for telephone directly, but our suspicion as to why the other campaign's numbers are so high are A, they had physical campaign offices.
No, you're saying that those were claimed under advertising of 20,922.
Right, they're part of the
It's
advertising.
just a classification difference.
It's a judgment call. Invoices that are for placing calls, promoting and reporting back as to what people said is much more than a telephone cost. And it was quite logically, in my submission, reported under advertising. It's marketing.
Okay.
Mr. Cashin refers to the internet URL or URL, bonniecrombie.ca. Bonniecrombie.ca is personal property of Bonnie Crombie. She used it first in her nomination campaign, seeking federal office. It was hers. It was then utilized in the election campaigns, as a candidate certainly can utilize her personal property. In the municipal campaign, it wasn't even rewritten. All that was done was to place what is called by my client, and I've heard the phrase, whether it's technically correct, some of you may know better, a redirect or a hot link, so that when somebody went to bonniecrombie.ca, it actually flipped you right over to Vote Crombie. Vote Crombie was established exclusively for the municipal campaign by a volunteer. Not somebody who's in the business of doing this, so it did not need to be reported as an expense. The value of web hosting for a month, it was a contribution of the value of less than $100 by that volunteer, with no obligation that it be listed here, because it's under the threshold.
And how do you come to the value of $100?
Typically, the web registration hosting costs for a month, in my experience, are for a non-commercial, non-elaborate website in the order of $25, $30 at most. That's personal experience. I'm not really here to give evidence, but the notion that it is worth some large amount that has to be declared would require evidence not from Mrs. Crombie, but from Mr. Cashin, and there's none before. Mr. Cashin kind of acknowledges that,
I thought it was just
and I prefer to wait and speak to the
we have a quorum. It's your choice.
Okay, I'm sure you can make it quick. It might help me to just review and see if I think I'm coming to the end of the whole one. I'll make sure to take advantage of the time that way. Didn't want you to miss the thing.
Thank you.
The submission from Mr. Cashin, as I was starting to say, is actually predicated on speculation and acknowledges that he can't know, doesn't know, and has no evidence as to where the bonniecrombie.ca hurdle comes from. He says if it was purchased by the federal EDA. Again, the obligation would be upon him to show that, not to speculate about it. That's not compelling evidence that is at all credible to say, well, maybe it was. An assumption cannot be credible information. Moving then to issue number 5. Unless you have questions about the board.
You may have a question there, Mr. Mayor? You have anything to make that up? You do? No? Mr. Chapman?
No.
Mr. Chapman? No. No.
It's somewhere around here. No, no, no. There. There it is. No, no, yeah. There's the complaint. Much bigger table. Issue 5.
Issue 5.
Failure to disclose or underreporting of salaries, benefits, honorary, professional fees. Let's go through the same exercise we've gone through a couple times now. Where's that? Section 66. What are the supposed, or where are the supposed violations? All subsections of the 66, subsection 1. That's interesting. Section 66 defines what a contribution is. It can't possibly relate to failing to properly evaluate and report all contributions. That lies elsewhere, but it was done. And he's provided no evidence to the contrary, mere speculation. Mr. Cashin's entire submission on issue 5 is speculation. Referring to subsections again of subsection 69. Now we're getting to the candidate obligations. We're a little bit more on point. Again, he says all subsections. It would be helpful for him to identify with some detail actually which sections he's referred to, because this can't possibly relate to opening campaign accounts at a financial institution or whether money was deposited into the campaign account. He's referring specifically to keeping records. Let's use that phrase. Keeping records, which some of these obligations in 69 plainly relate to. Keeping records, you cannot possibly, from a campaign return, with answers to the questions asked on that return only, on the financial statement, determine whether or not records were kept. You can't make out a breach of a record-keeping obligation based on any of the information that Mr. Cashin would present. Then we have failing to keep records of the fair market value of goods and services provided by Solus One, basic communications, etc., etc., etc. We need to talk about these one at a time. Some of them were suppliers in one way, shape, or form. Others, no. Solus One. Where does this name come from? When I interviewed my client in preparation for today, they had nobody had any recollection, not her, not the people who were assisting her. What on earth Solus One might even be. I found it in preparing for the hearing today. That's the name on the invoice for that poll that we started these submissions with. Well, I've already made the submissions about why Solus One is not a campaign expense that requires a new report. Daisy Communications, Rob Trewartha, there's a slash, they seem to be a unified concept there. No services were provided to this campaign either by that company or by Mr. Trewartha. Now that sounds to Mr. Cashin to be counterintuitive. He told you that, lo and behold, Mr. Trewartha's name appears on the federal return as a supplier of services and that he was paid for. And, shocking though it might be, he's now employed by Mrs. Crombie. And therefore, he would have you infer that, well, he must have provided services. Totally apart from the fact that inferences like that are not compelling or credible evidence. The fact of the matter remains that Mr. Trewartha became a father on September the 3rd and chose to sit out the campaign as a result. I think he's allowed to do that. Campaign research is not an entity known to my candidate. I suspect, again, because of the style used by Mr. Cashin here, that it relates to a Mr. Nick Kovalis. Nick Cavalis. He is a conservative political operative, to my knowledge. He was, I'm informed by my candidate, the campaign manager of her opponent in the 2008 federal election, Mr. Khan. What we have here is a statement in Mr. Cashin's material that he is known, I may be missing the quote exactly, I'm trying to say limit time by not looking every quote up, but he's known to have been involved in the campaign. He was a friend of Mr. DeShiana, who was the campaign manager. That doesn't make him a friend of Mrs. Crombie or a supplier of services to Mrs. Crombie. There's been no evidence other than this bold assertion he's known to have been involved. As to any involvement, the fact of the matter is that I'm told that there was a chance encounter and a conversation that took place, and maybe somebody witnessed a conversation where these former political adversaries, or maybe even the candidate's representative, I'm not sure if it was her or somebody else, who saw it was her, had a conversation. That's not a provision of services. And to think, with any knowledge of the political context you may or may not have, the likelihood of a candidate bringing into the fold to provide the services somebody who is so very conspicuously associated with the political party that she has been opposing throughout her public life, it is counter to it. There's simply no evidence of it taking place, and you cannot, on an allegation like that.
Was any services provided by these companies?
Yes, by some of them. Yes, I'm coming
Prime
to one.
Contact?
Prime Contact, absolutely. I told you about it.
Canada
Two
Post?
invoices. Canada Post, not directly, but indirectly. Canada Post services were acquired through a company called Honeycomb, which charged for the Canada Post costs that they incurred. And that's reported under advertising. It was actually, to give you the fine detail, an expense that was directly incurred by Mr. DeShiana, the campaign manager, on his credit card and reimbursed by the campaign, which is totally proper. But that was the usage of Canada Post. Again, as I provide you with information, the fact of the matter remains that there's no evidence, credible or compelling information to suggest that Canada Post was used and not declared. This reference here to various volunteers, I'm not seeing much. Okay, and I'm sorry, I misunderstood my client. She's saying, and as well, to save costs, if you have volunteers in a campaign, you have people handle litter things. The issue 5 goes on, and other issues. 66(1)(f) is again the definition. You can't have a breach of the definition. 66(3) is failing to report amounts charged. Well, I'll be a little bit more generous to Mr. Cashin here. The definition, and this is what I referred to earlier a couple times when we talked about time, the value of goods and services provided as a contribution in 66 sub 3 is if the contributor's in the business, the lowest amount that contributor charges the general public. And if the contributor's not in the business, then the lowest amount a business that is in the business charges for these things. The lowest amount. That's not even fair market value. That's minimum market value. So when you put your minds to all these other issues before and whether or not a brochure cost you heard about at the $8,000 range comparable to a $10,000 one, there needs to be evidence that there was a break provided here, because the lowest cost means the cost you charge your best customer. That's actually a supplier requirement, an obligation under law federally and provincially for suppliers and campaigns that they charge the lowest cost out. 69D, she's said to have violated, which is ensure that contributions of goods and services are valued. Any goods and services that have been brought to the campaign that have been identified here, we've explained how they were valued, so plainly it was done. 71.1, exceeding the total contribution of $750 per person per candidate. What you heard from Mr. Cashin on this was something about the man in the printing business, Mr. Gray. There's simply no question that a corporation, his business, can contribute $750. It doesn't matter who the signing officer is. He, as an individual, can contribute $750. There's simply no over-contribution when the corporation and the individual give in this fashion. In fact, I suggest to you that it's quite commonplace. That's the only answer we've got about over-contributions. It's simply not there.
Issue 5.
Unless you've got, I'm done unless you've got questions.
Yeah.
What I'm taking from this is that the elections act is pretty worthless.
I want you to direct you to the financial statements and the schedule attached for the donors.
Yep.
2 pages.
Go flipping, but I know what I think you're going to do. Yep.
And before I start here, we all aware that the maximum limit by subsection
It's 750. It's all.
750, right?
Yep.
Number 4,
Number 4.
5. Number 5.
You're referring to subsection.
No, I'm referring to sheet
I don't mean my number 4.
the individual, contribution from individual other than candidate or spouse.
Yes. The fourth person.
The fifth person, after the normal,
Yes.
there's a contribution from him is $500.
Yes.
If you go on the next page,
Ah, that's the schedule. Ticket sales. Yes.
ticket sales. And his name appears there also. Number 3rd from the bottom up, individual, 1 attendee for $500 ticket also.
That's the same contribution, reported in 2 different ways.
But-
The schedule, okay, the second page of this list of names, look at the top of it. It's ticket sales attendees. In fact, it was done this way, but there's actually a schedule to the form prescribed by the Ministry of Municipal Affairs and Housing. I can't recall the schedule number, that requires each fundraising event to be the subject of a separate list showing just this detail.
Schedule 2.
Ticket sales, Schedule 2. This is in lieu of the Schedule 2 form because it's being computer generated. It shows where the money came from for ticket sales. For this particular event, or events, 19 paid attendees for a total of $5,150. But this money would all be repeated on the previous page, which is the global schedule of all contributions.
But it also says may not exceed individual contribution limit, which is $750.
Correct.
Right?
Yeah.
Okay, so we're on the same page. So let's go back to the schedule here. I just want to clarify certain things here. So we talked about Mr. After Donovan,
Yep.
Jack Maloney,
James Maloney.
James Maloney, sorry.
$500.
$500.
Yep.
He shows up again on the
Absolutely.
event.
Yep.
Julian DiCamino, Gicciano, sorry.
Shanna. Yep.
He shows up
Exactly.
again
Because
on the individual
it's
ticket.
2 locations.
I just want to
report the
confirm
same
something.
transaction.
Paul Gray,
Yes.
$750.
Yep.
And Paul Gray was a signatory, as mentioned by Mr. Cashin here, that he had a company here. Which was that? Boss Printing.
Boss Printing, yeah, I'm aware.
And the Corp has contributed $7,500 and
I'm sorry, 75?
$750. And Paul Gray has contributed $750.
Yes.
Bloomingdale limo,
Yep.
$500. Bloomingdale limo also shows up again in the event, or fundraising event, $500. Brampton hardwood floors, shows up again.
Yep.
You with me? Rex lumber. Rex lumber also shows up as right after James Maloney as a family of four, $750.
Right.
Okay, and
I think every single entry on the second page is matched by an entry on the first.
so it's just giving us more detail here.
It is a requirement of the form that the candidate report the fundraising event, each discrete fundraising event on this schedule. You indicated it was Schedule 2. This is the equivalent of the Schedule 2 for the purposes of this return. And it is on a larger campaign, you could see 4 or 5 Schedule 2s for 4 or 5 different fundraising events. And each transaction on those 5 schedules needs to be reported in the overall listing of all contributors. Each Schedule 2 is a component of the master list, which in addition to showing ticket sales for these fundraising events, would show direct contributions that weren't a purchase. Well, in fact, it's not if, I'm on here. I made a contribution without attending an event. I'm on the first schedule, but not the second one.
Just want to clarify.
Okay.
Okay, any other question on issue number 5 from my colleagues here? No?
No.
Okay, let's go to the final issue,
Final
and
issue.
you've got, your time limit is 10:40. So if you want to finish it, I'll,
Okay,
couple minutes, I can give it to you.
Finish rather surprised.
I mean, I'm not going to pressurize for time, but if you need
I can wrap on this one. I'd like to summarize
You
as well. We'll
to
just-
take a reasonable extension.
Okay, issue 6. My bill. That's really what we're talking about. We're talking about my account for services rendered in October for the hearing of our meeting of October the 25th. Mr. Chung's questions penetrated right to the heart of it. The expenses of a compliance audit do not equate to the expenses of legal representation at a hearing to determine whether or not a compliance audit can take place. That in and of itself should be a full answer to this complaint, but I'll go you one further. I issue my accounts generally on the 15th of each month. My account to Mrs. Crombie was issued on the 18th of November, outside of this campaign period. You can't quantify the contribution or the expenditure. My slip of the tongue. It's getting late. If you can't quantify the expenditure in any way, and she had no knowledge of what I was, she might have had a ballpark idea, but she didn't know what the total tab was going to be until I rendered an invoice. It's outside this campaign period. And it was paid outside the campaign period. I'm happy to say that it was paid.
So she did not ask you for what the reasonable amount will be before she...
She had an estimate. I'm afraid I went over. Try to keep it down. And my client tells me that out of an abundance of caution, because I would maintain it's not an obligation, given the point initially raised by Mr. Chung. Out of an abundance of caution, it will be reflected in the supplementary statement she has to file, because there's a further campaign period extension going on. But she wasn't invoiced during the campaign period, is what would happen. It simply is a matter of my routine business practice. And it's not an expense. It's not within that definition. If I can summarize very, very quickly, because I think you've heard a lot and you get the gist of it.
I heard from both parties. I will give you both parties 5 minutes to include now final submissions. I'll give the accountant, the applicant 5 minutes, okay, and then we'll come back and you give us a summary of 5 minutes.
That's fine.
We'll go
Yeah,
through
okay.
submissions, finals.
I was concerned that there might be points raised by Mr. Cash that I hadn't heard
That will
before.
prepare you.
But if I'm going last, then that's our thing.
I'm just following procedures. Okay, we heard both parties. Anybody has any questions before I give them final 5-minute submissions?
Do you mind a quick break?
2 minutes? 3 minutes? How long do you want?
Just a bio break would be great.
No problem.